Good evening, ladies and gentlemen. I'd like to welcome you to tonight's Board of Adjustment meeting, September 27, 2017. So we'll call a meeting to order, and first an opening statement of purpose. The Board of Adjustment is authorized by the Arizona Revised Statutes and the City of Tempe Zoning Ordinance. Its function is to grant relief where a literal enforcement of the zoning ordinance would result in an unnecessary property hardship, to interpret provisions of the zoning ordinance, and to hear appeals from any person or city official aggrieved by the decision of a person responsible for the enforcement of the zoning ordinance. The board has the board has the City of Tempe Community Development Staff Summary Reports on the items being considered at this meeting and will use this report in their deliberations. We're glad to see a few of our Tempe citizens here tonight. Obviously, we have our applicant, and they will have a chance to speak. If the rest of you would like to speak, we do make provision that you can have a few minutes to speak. In order to do so, we ask that you fill out one of the white forms at the back on that table and bring it up to a member of our city staff. And when we get to the appropriate time, we'll have you come up and you can share your feelings. With that, I'd like to introduce our staff tonight. We have with us from the City of Tempe, Steve Abrahamson, Karen Stovall, Ryan Levesque, and Diane McGuire. To my left, well, I believe we're going to introduce ourselves. If we can start at my left.
Kevin Cullens.
John Pazalskis.
I am Vice Chair David Lyon.
I am Dave Noggle.
James Frazee.
Al Derrick.
Thank you, board members. So our first item of business tonight will be to consider the meeting minutes for our previous meeting dated August 24th, 2016. We have reviewed these minutes during study session, and I will now hear a motion regarding them.
I make a motion to accept the minutes, approve the minutes.
Do I hear a second?
Yes.
Okay, motion to approve minutes from board member Pazakis and seconded by board member Dare. All those in favor, please indicate by show of hands. Okay, that passes 5-0 with 2 members abstaining, I believe because they were not present. With that, we'll move on to our remaining item of business, which is, where's our number? Case PL 170205, 410 South Madison, Suite number 2. And we'd like to begin by allowing Ms. Stovall to tell us about the case.
All right, good evening, Chair and board members. This is an appeal of the zoning administrator's decision made on July 17th, 2017 to deny a proposed medical marijuana dispensary located at 410 South Madison Drive, Suite number 2. After review of the application, staff determined that the subject property did not comply with the separation requirement from another medical marijuana dispensary because the city had accepted a dispensary location within a 1-mile radius of the subject site. The appellant's letter of appeal, which was dated July 31st, 2017, was included in the staff report attachments, and it sounds like you have had an opportunity to review that. If you don't have any questions of me, I'll let the applicant or appellant make his presentation now.
Do we have any questions? Okay, we may ask you questions later, I suspect. Before we go any further, I'd like to point out an error that I realized I made. I said that our motion to approve the minutes was put forth by Mr. Pazakis. It was put forth by Mr. Causel. Okay, so having corrected that error, thank you, Ms. Stovall. We'll now have an opportunity to have our applicant approach and tell us about his case.
Good evening, members of the Board of Adjustment. I appreciate your time to hear this matter. My name is Brian McLaren. I'm the CEO of Zoned Properties. We are a real estate development firm here in the Valley. We own the property at 410 South Madison Drive. For the past few years, we've attempted to work as collaboratively as possible in developing a concept that we call the Medical Marijuana Business Park at 410 South Madison Drive. So we have a primary tenant at the facility that is currently a licensed and permitted medical marijuana cultivation site. They are our client, that's Hannah Meds, who's listed in the description. They approached us with an interest to also develop, as a part of that concept, a dispensary site. So we worked with the development department, PD, fire department, city attorney's office as the best way to approach this. We've tried to work as transparently as possible, and here today in the capacity as the appellant on, unfortunately, the denial we received for our submittal for the permitted site. Completely understand why we received the denial, and hoping to have a conversation, answer any questions that you may have from the appeal we have that's in front of you today. So thank you for your time, and again, appreciate you hearing this matter.
I'm going to go ahead and start, if I may. I think it might be appropriate if you would actually take a few minutes to go through your arguments. There's been some discussion about what exactly the arguments are, and I think it's better if you state them yourself.
Sure. I guess our interest is in this process finding the most equitable way that we might be able to approach furthering the development of the facility. So, you know, we've been a part of all the city council hearings and meetings, as this was a pretty contentious topic that was discussed. A lot of stakeholders and community citizens weighed in with those opinions. So from, I guess, the approach we took and what we included in the appeal, so I was one of the individuals who sat outside for it was probably about 12 and a half hours the night before the Monday morning submittal where this application process took place. So it was quite a warm, long evening just outside the doors to the development office. From our understanding of that process, the submittal was supposed to be a first come, first serve on behalf of the applicant that was submitting for a medical marijuana dispensary permit. The process by which that first come, first serve process took place seemed a little gray. There was some instruction that was posted a few weeks prior to that Monday morning submittal. And to clarify the backgrounding, if that wasn't already understood, this was the Monday morning that was 30 days after the city council passed this new ordinance. So the amendment to the previous ordinance had limited the number of medical marijuana dispensaries in the city of Tempe. The amendment to that code took away the limit and said that they just had to be outside in 1 mile proximity of each other. So our site, which we've developed for the past few years, already had a cultivation on the property but did not have a dispensary, a retail site for medical marijuana. So 30 days following the decision of the City Council to amend the ordinance, the application process was opened Monday morning at 8 a.m. So when I say I was there 12 hours, a little over 12 hours, it was 8 p.m. Sunday evening waiting for that door to open. It's kind of like a first come, first serve for the new iPhone kind of a deal. So when we got there, there was a security guard sitting in a chair right outside the development department door, and there was a single-page notice on the door that said, this is the single door that applicants should enter through on the first come, first serve basis. So when I arrived as the applicant, I was a little unsure of who the security guard was that was there. After about an hour of small talk with this guy, I learned that he was there on behalf of another applicant. So I had no idea where that applicant was applying, where the property was. All I knew at that time is that I was sitting in a chair that was not the immediate chair right next to the door. Our position and how I approached this was throughout the night, that first chair position and security guard left. So they left and came back, and I stayed there the entire time. So there are several very odd selfie pictures in our submittal that show me as the only person sitting outside that door. From my understanding of the application process, that was a first come, first serve for the actual applicant, not a person you could hire and put in place to save your spot. Had we known that, I mean, these are fairly competitive permits, we absolutely would have spent the money to have someone sit there for 2 weeks, for a month. So it's that, I mean, that's as much of a big deal in what these permits are worth, especially for our property that we're trying to develop as a comprehensive safe and sustainable site for medical marijuana operation. In the morning, the city staff, Ryan, and one of his other development staff members approached, and about 10 minutes before the 8 a.m. arrival, I think it was 3 or 4 maybe members of the actual company that was trying to apply that had hired the security guards showed up, switched places with them, and then they were kind of saying, we are number one. So at that point in time, 8 a.m. in the morning, I wasn't really in a position to contest that. Frankly, it didn't feel safe to me. I didn't know who these guys were. I'm usually a very cautious person. I'm a development builder, sustainable development guy in my professional history, not a marijuana guy. So I wasn't about to contest with a group of marijuana operators I didn't know in front of city staff. So we ended up taking a Post-it that said number 2. We submitted 30 seconds behind the first place applicant, who happens to be within a mile of our property. Haven't seen much activity at their site. It was the old appliance depot site with the green awning on University and Madison. And we're quite a ways back where Madison kind of turns and elbows into 4th Street. So that's a little bit of the history of where we're coming from. My interest is to continue to work collaboratively with the city of Tempe. I'm an ASU sustainability alum and would very much like to see the medical marijuana industry developed in a way that meets the needs of the city and its citizens. So that's the background on our appeal and our position.
Okay. Thank you, Mr. McLaren. Board member questions? Board member Causel.
Hi. While you were standing in the line and having discussions, small talk with this, did you have any idea that he was going to infringe upon your facility?
So earlier in the morning, a few hours before, maybe it was 5 a.m., I learned that they were in what's called the Northern CHA. So your city of Tempe, is divided into 2 what they call CHAs. It's an acronym, CHAA, Community Health Association Area. And those are the districts that the state of Arizona Health Department governs for the marijuana licenses and permits. So my understanding on the history of how Tempe laid out their zoning code is they basically tried to follow the state. So there was a North CHA and a South CHA. The northern area, as soon as you kind of learn that their group is in the northern part, there's only so many locations that it could be. So we're quite familiar, being a property that's been here for several years, which other locations are kind of the regions of where this might be. With a mile setback and proximity restriction, as soon as they said north, it was probably a 90% chance that they were within a mile of the property.
Thank you.
Yeah.
Board member Frazee.
So just a couple quick questions. So you were there 12 hours. You never left your space for the 12 hours you were there?
I switched once with another member of Zone Properties just to go to the bathroom and come back, and that was maybe at midnight.
So do you know how long before you were there, they were there?
I don't. I mean, I heard several different things from the security guards. So 4 different security guards switched out during the time that I was there, 3 or 4. And several of them shared different things just in small talk of the people that hired them. So it sounded like they'd maybe been there for even a couple days, potentially since. So I think on one of the exhibits, it might be Exhibit B, on the appeal, there is a picture of the single-page notice that was posted on the glass door.
Yes.
I believe they were there when that was posted. So that would, I don't know for sure, but it sounds like Friday at close of business, basically.
Thank you.
Mm-hmm.
Board member Pizakis.
So the person or the entity that went in and got the approval of the permit ahead of you, did they have a Post-it that said number 1?
I presume, I'm not sure. I presume so, but I don't, all I know is what I had.
So you had number 2.
Correct. Yeah.
When did they give you the number 2?
About 2 minutes, I think, either 2 minutes after 8 a.m. or a few moments before was the kind of approach to sign in to the submittal desk.
So, okay, so what you mentioned, you want to work, and I mean, you knew this happened. You obviously acknowledge that you went in as Post-it number 2.
Sure.
And I think, So you mentioned you wanted to work in a collaborative fashion. What do you envision that is?
So maybe I'll answer that as kind of a past and future. So we actually did submit as the applicant several years ago a code amendment. So the original code amendment under the medical marijuana program restricted the size of facilities by a single, I think it was entrance and exit egress to the actual facility. So for most sites that limited the largest a development, dispensary, or cultivation could be was about 5,000 square feet. So we submitted and worked with the development office on there weren't too many changes, I think, to that amendment. There were maybe 3 line items that changed that allowed the facilities to have multiple means of emergency exit, greater security and limitations. As part of that process, there was a separate applicant. Our application on that code amendment was specifically for a business park as a whole and cultivation site. So that's what we have on our property for our tenant and our client. There was a parallel application that was submitted regarding dispensary changes. I believe they approached hours that a dispensary retail site could operate, the age of those that could enter the facility. So we had submitted as the first applicant, and there were problems, I believe, in either the submittal process or the timeline of this other applicant. So we agreed basically to patiently wait, I think it was 3 to 4 months, to delay our application to be heard by the city council so that the entire matter could be heard all at once. Just made more sense. So in that sense, we've tried to be as flexible and patient, and have heard what city council members. We've met with a lot of community citizens. I've met with members of ASU staff to hear their concerns, what they're worried about, nervous about. We've toured the facility to Tempe PD, worked with Commander Hale, with the fire department to say, what are your concerns? To me, as a developer, I want to make sure if they're ever called to the facility for a fire, they feel safe going into the facility, that they know what the facility layout looks like. So that's traditionally not an approach a lot of developers in this industry nationwide take. Usually it's a lot of, no, we don't want you to enter, I'm going to refuse you at the door or come back with, a lawyer. So for us, we want to develop this facility as a long-term value for the community. For me, I'd love to see this facility go carbon neutral. So we're working on a master plan that provides solar-covered parking, working on wastewater reclamation and treatment. That's kind of my professional background and passion, which I know is a big interest for the city of Tempe as well. So I hope that answers your question.
Board Member Frazee.
A follow-up question. So when you reference as a business park, the reference is though just for the building, correct? Or does it encompass other buildings in this
so
park?
just that one building. So it is 2 parcels of property that the 60,000 square foot warehouse building sits on. So I'll maybe give you a little bit of background from the state level, and please interrupt me if this is repetitive, if you have this already. But basically the state requires often that a multi-use facility, so usually when operators get a license for medical marijuana operation, they get 3 main pieces: a cultivation, a processing or kitchen, and a dispensary retail. So those 3 pieces can be separate, or they can be all on a single site. The state code prefers, it's a little bit gray, but prefers that if you have multiple of those 3 pieces on a single site, that you treat that site as a whole, the property, so a secured perimeter that's cameraed, that's well lit. You have to have, the actual operator has to be able to provide 40 days of camera activity to state auditors and inspectors. So when I talk about the business park, I'm referring to a multi-year master plan for the property as a whole. So
For just the building, though, not the surrounding buildings in the existing park?
Parking space included.
Okay.
So my intention also is hopefully to move towards a LEED certification. So we would want to include access for public transportation, bicycles, walkability factor, spaces, green space for employees to sit outside and have lunch. So I'm referring to the property as a whole, but the operation itself only occurs within the perimeter of the building.
And then when you talk about the zone, being this northern zone, your existing cultivation facility is going to be the cultivation facility for that zone?
Yes, but there is a possibility that multiple cultivations can be located in a single zone. So originally when the state issued, I believe it was back in 2012, issued the lottery system of all these first, there were 99 licenses. And it was a literal lottery. People applied and, you know, balls popped up, and if your number came up, you got a license to have those 3 pieces. The cultivation site could be anywhere in the state, so long as it met local zoning requirements. The retail dispensary had to be located within that CHA, that district. 3 years following a dispensary being operational, it was then allowed to move anywhere in the state. So one of the reasons that I think this became an item of discussion and concern for the city of Tempe is that many of these facilities 6-9 months ago had reached that 3-year threshold. So that was, from what I could tell, listening to discussion and concerns of the city council and community, was what originally called for that limit of 2 dispensaries in Tempe.
Board Member Dare.
I have a question. Somewhere in your paperwork, you mentioned that on the day that they opened up, that I suppose you all walked in the room, in the office, and you say that someone asked who was first.
Correct.
Do you know who that person was?
Ryan might be able to better answer this. I'm not sure if it was Ryan or your employee that was with you.
Yeah, I can answer that question. So Chad Weaver, the Community Development Director, had the idea of noticing that there was a group of people out in front of the door before the 8 a.m. opening of the door. And he decided to write on a Post-it note, number 1, number 2, and number 3. And we both went out there together to approach the folks that were there near the door, and we asked who was looking to apply for medical marijuana. All but 3 groups answered, except for one other gentleman was here just for a general permit. And so he asked them on their honor system who was the first person here in line, and they all pointed over to their right side as being the first applicant. Now there was a group of people there, like 2 or 3 people, and so they took that. You referenced a security person, so that person was there, as well as a couple other people that were in that group of people, as well as Mr. Brian McLaren, and then another 3rd applicant that was on that site. And so he handed the Post-it notes, number 1, number 2, and number 3, so that when the door opened, unlocked, they then signed in to the sign-in sheet at the front counter, and then just basically waited to be called upon to basically process their application. And so then that became basically the order that we received the applications and reviewed them individually.
And if I may, it was very clear physically who was physically at that time closest to the door. So I have no contest to that. My real argument is that there were multiple times throughout that 12-hour period where their representative left the position, and I could have physically moved into that first place, but I wasn't really about to get into a scuffle with someone about. At one point, I guess it's a slippery slope of if you're waiting in line, but at that point there's no established order. It would have made sense to me that if sometime prior to that the numbers were given out and that was established. But if you're waiting in line for, I equate it to like a new iPhone, or if you're waiting in line camping out for a concert ticket and someone leaves, I suppose there's a moral argument one way or another whether you should save the spot for them if it means you'll lose that opportunity, or whether it's their obligation to physically remain in that position. So no contest from my perspective who was at 8 a.m. when Mr. Levake and his employee stepped out, who was physically next to the door.
So I have a follow-up question to that. So when you arrived the 12 hours in advance at the office where this was going to take, a very important thing for the city of Tempe was taking place.
Yep.
Other than the note that was on the door, at any time between the time you arrived there and the time the doors were opened, was there a city official of any type, a police officer or anyone there to monitor who was first?
I believe there was another security guard that was making rounds of just the city hall grounds, but I'm not sure whether he was an official City of Tempe staff member or whether he was a third-party hire. So it was difficult for me throughout that evening to determine which of these security guards were sitting when they were exchanging. But there was one other gentleman who seemed to me to be kind of just monitoring for safety. So, which I did appreciate that. I mean, middle of night sitting below the pyramid is a little dark sometimes.
Now, the next question I have for you, thank you for that. This arbitrary 1 mile limit that was then, which is the new ordinance for the
Correct.
city of Tempe versus the old one where we only had 2 dispensaries, period.
Correct.
If a decision were made to allow you to have a dispensary down in Madison, would you object to there being another dispensary up on University?
Not at all. Our position is just let us compete. You know, this is an open market. We've had the intention to develop this business park for the past several years. We've owned the property since March of 2014. No problem with a competing, at least certainly I don't have a problem as the real estate developer. I don't believe my client, the actual operator, would have a problem with it either. I mean, in fact, I think the original conversation we had years ago was that a lot of the crime data shows that if you actually group the operations together, there are less incidents. So we had pulled some national crime data where if you located these facilities closer together and local police department, fire department, and safety officials knew exactly which of the sites were licensed and which were not, that would help them out. My understanding is it's somewhat difficult for local police departments and safety officials when there is not a licensed dispensary in your municipality to figure out at first whether it's a licensed or non-licensed facility. So some of the feedback we had heard during that first code amendment was that it actually was maybe preferable to have these facilities closer together. So a longer answer, but the short answer is no, we would not have an objection.
Thank you.
Board Member Pizakis.
Thank you. Just one last question. So if really you are recognizing there was no contest relative to first in the door for whatever reason, and you appealed your application and it was denied for nothing more than somebody was there ahead of you. So
I guess maybe I can clarify to your question.
Well, my question is, what exactly are you asking us to do? I mean, obviously, we're going to vote on something, but what are you asking?
Sure, and to be clear, I don't have a contest to who was physically there at 8 a.m. in the morning at what physical position. I do have contest to who should have been first in line during that waiting period. So as a first come, first serve, to me it's like a queue. You have projects sitting in a queue, and if one drops up, the rest shift to the front. So if you follow that logic and building permit submittal process, that would mean I would have physically been able to move into that first position. So just to clarify that for that question, what I think we're seeking is just basically to allow ourselves to be able to develop our facility with that permit. Just let us compete within the city. Thank you.
I have just one last clarification. I think I know the answer, but I'd like to hear you say it. Is it true then, when you were asked who was first in line, that you did indicate the other party?
Yeah, so I kind of motioned towards the guys who are in front of the door.
Okay. So I would like to, well, do we have any further questions for our applicant? Well, I'd like to say I find you to be a very reasonable person, and thank you for sharing your thoughts. I'll have some more comments later.
Sure, thank you.
Okay, so ladies and gentlemen, we now have an opportunity where you in our audience may have an opportunity to speak on the case if you so wish, and express your support or lack of support. We like to ask people to keep their comments to 3 minutes. That's part of our process. We just keep things nice and orderly here. Everyone gets a turn. So if you wish to speak, we can, do we have any cards from our?
No, Chairman Lyon, we do not.
Okay, so last chance. If anyone wants to speak, please indicate now. Seeing none, I will close the public comment section. And that brings us to our board member discussion section. Would anyone like to open comment or begin posing questions or any such things? Commissioner Board Member Coswell.
I will take the opportunity to thank you. And I do not personally agree with the process and the limitations on these facilities. But I just find myself in this role here having to comply with the law that's there. It sounds to me like this is really an issue with the law, not over what happened that day in the number 2 spot. I don't know whether or not you can contest the city ordinance at the state level or not, but I personally, I struggle with making that decision, but unfortunately, I think I know where my vote is going to go. Thank you.
Other thoughts? Board Member Dare.
Mr. Dare, microphone.
I have a thought that for the board that who's on first and who's on second has been proven many, many times ever since the days of Homestead in the great state of Arizona, who was there first. And I as a citizen feel, and though I love them very well, I believe we did not adequately provide a way to determine who was going to be first. Therefore, it should have been established in advance, because this is a very, very lucrative business. And I just think we let them down as a city in not better preparing the applicants as to how they would be determined to be first. So that's all I'm saying.
Okay, thank you. Other thoughts, comments, questions? I will share our thought if no one else is inclined. Yeah, I would like to say, Mr. McLaren, that I find you to be intensely reasonable, and you strike me as a very candid person. And that I just want to say that it's been a pleasure to read your letter and to hear your remarks. Sometimes we have people come and make their case and they aren't so reasonable. So that is appreciated. That being said, we're not here to pass judgment on you as a person. I think for me, the matter really comes down to who in fact did get the application in first. And you've raised this issue about, well, who technically should have been first. But I'm afraid I think you were maybe a little bit too much of a nice guy and indicated that those folks were there first. And I think that would have been the time to defend, no, by rights, I really should be here first because I don't think this person is acceptable, or however you wanted to think about it. But the way I see it, the opportunity to make your case that you were first was right then, and I think that you missed your opportunity. So I'll say that for benefit of my fellow board members, I believe that I would vote to deny the appeal, that whether we like the system or not, I do believe it has functioned as designed. So, other thoughts, comments, questions, debate?
Mr. Chairman, I have a motion.
I think we may have one more comment first. Board Member Dare?
Just postpone it for just a couple moments here. Not that it'll make any difference, but I do believe the applicant, I agree with what you said. That would have been the time to say, okay, if you had the muscle to do so. There are times when we feel intimidated. And I believe the testimony is that the number of 3 individuals came up. That could be implied as intimidation too. So I don't put too much bearing on the fact that he did not object at that time. We all know what strong-arming is in this old world. So, thank you.
Okay, fair enough. So, do I hear a motion?
Right here.
Okay. Board Member Noggle.
I move to deny the appeal of the zoning administrator's decision to deny the proposed medical marijuana dispensary location at 410 South Madison Drive.
Do I hear a second? We will clarify in a moment.
I second the motion.
Okay, so the motion is put forward by Board Member Noggle and is seconded by Board Member Causel. And correct me if I'm wrong, I believe the motion is to deny the appeal, which will have the effect of upholding the zoning administrator's decision. Is that correct?
Yes.
Okay, so all those in favor of denying the appeal, please indicate by a raised hand. And those opposed. Okay, so the motion passes with a vote of 6-0 with Board Member Dare in the negative, which has the effect of denying the appeal, and the zoning administrator's decision has been upheld. Okay, so having finished that piece of business, we have city announcements, I believe. Are there any announcements or city business?
Well, a couple of things, and correct me if I'm wrong, Mr. Levesque. Should that have been done as an affirmative? We're good. Okay. So, given that the vote was 6-1 to deny the appeal, the decision made by the zoning administrator is upheld. Beyond that, if you would, go over the appeals process. Should they wish to appeal it, it goes to Maricopa County Superior Court.
Okay, well, actually, I'd like to lean on you because I'm not
Okay.
skilled enough at describing the appeals
Okay.
process, if you would.
Should the appellant wish to further appeal this process, goes to the Maricopa County Superior Court, and you have 30 days in which to apply for that appeal. And that's to the court, not to the city of Tempe. As far as announcements are concerned, yes, city of Tempe, or I should say the city of Tempe recognizes National Planning Month for the month of October. There will be some further announcements made, but October is Planning Month, National Planning Month. Thank you.
Okay, and we do have a Board of Adjustments meeting in October.
We do at this point. We have one scheduled for Wednesday, October 25th. The study session is at 5:30. The hearing is at 6 o'clock.
Okay, very good. Well, then let's have a motion to adjourn then. Can I hear such a motion? Board Member
Motion we
Frazee.
adjourn.
Second?
I second the motion.
Votes? And we are adjourned. Thank you, ladies and gentlemen.